Australia Security and Investment Commission is seeking order of the disqualification from managing corporation and disqualification from providing finance service and pecuniary panels against individuals who, under Mr. David Hope's guidance, operate unregistered funds that he has set up the offshore. The scheme involves Australian investors subscribing to so-called investment education package and setting up the personal offshore companies in which they would then scheme their investment through in an attempt to prevent the Australian laws regulating financial service and products and protecting the interests of Australian laws. The defendants encourage Australian investors to participate in the scheme using false representations. Today, we will focus on the personal contravention by Mr. Hope.
So, the personal contraventions by Mr. Hobbs are outlined from a variety of provisions in the Corporation Act. So, first we can take involvement in the operation of unregistered managed investment scheme. So, according to Corporation Act 601, a managed investment scheme must be registered. So, secondly, providing financial services within Australia without an Australian financial services license. So, a person who carries on a financial services business in this jurisdiction must hold an Australian financial services license covering the provision of the financial services.
Mr. Hobbs, as well as his colleagues working for financial services, working for a financial service company, were making false and misleading representations about their financial services. They have stated to their clients that their offshore investments were legal, investment was capital guaranteed and principal protected, that the promised return, the investment would return likely around an amount of 4% per month, and that the investment could be redeemed on 60 days notice after 12 months. Now, all these factors that they have said to their clients were actually false, because as my colleague has said before, his financial services were not legal, and they aren't even registered within Australia, so that does not make them a legitimate company. Furthermore, they have stated that the capital guaranteed was their investment was capital guaranteed and principal protected. That was also false. At the promised return, the investment would return likely around 4% per month. That was also false. And that the investment could be redeemed on a 60 days notice after 12 months. That was once again also false. Now, this relates to the law here. According to the Corporations Act, Section 1041H, it states that this prohibits a person from misleading or deceptive conduct within Australia in relation to a financial product or a financial service. Now, Hobbs, with his position as a director in a company and providing a financial service, has done exactly that. Furthermore, in Section 12DF of the ASIC Act, it states that a person must not in trade or commerce engage in a conduct that is liable to mislead the public as to the nature, the characteristics, the suitability for their purpose, or the quantity of any financial services.
Finally, improperly using his positions as a director to gain a financial advantage for himself, such as a receipt of the commissions payables as an introducer or broker for some of the investors. According to Corporation Act, Section 182, Subsection 1, a director, secretary, or the officer or employee of the corporation must not improperly use their position of, gain an advantage for themselves or someone else, cause detriment to the corporation.
In conclusions, based on Mr. Hope's personal contributions, the court found Mr. Hope was the mastermind behind the scheme with effective control over all the scheme funds, and there was ample evidence of improper payment out of fund money, including Ponzi payments. Pursuant to Sections 206C and Sections 206E of Corporation Act 2001, order were made on Mr. David Hopes be permanently disqualified from managing any corporations, permanently restrain him from being involved in any managed investment scheme, and from the financial service business.